Looks to me like the parties are about ready. State versus Woods. Ms. Donels, you may begin.
Thank you, Your Honors. May it please the court, opposing counsel. My name is Jess Donels, and I represent Mr. Kevin Woods. Mr. Woods' rights under the Iowa Constitutional Amendment 1A and the Second Amendment were violated when he was criminally prosecuted and convicted for possessing a handgun at the same time that he possessed a user amount of legally purchased marijuana. Under Iowa Constitutional Amendment 1A, the standard to be applied is strict scrutiny, whether there is a compelling state interest in disarming and criminally punishing Mr. Woods for possessing a handgun at the same time that he possessed a user amount of legally purchased marijuana, and whether the statute is narrowly tailored to further that interest. The compelling interest put forward by the state in this case is preventing dangerous firearms violence, and we conceded below and we concede here that that is a compelling state interest. However, that's not enough. The statute has to be narrowly tailored, and in this case, it's both broad and too narrow.
And I didn't see in the record what the quantity of marijuana was. I saw that there's the 2 vaping pens and some amount in a container that I assume is a personal use quantity because that's all that was charged. But I didn't see an actual quantity. Is there in this record any note of what the quantity is?
Your Honor, the minutes of testimony labeled it as a 1-ounce container of marijuana, which was commercially purchased. However, the minutes of testimony themselves don't establish whether that container was full or not. So whether it was actually 1 ounce is a question that's not within the record before the court. I could answer based on the discovery, but that's not before this court.
Help me with with the strict scrutiny. That's your Article 1, Section 1A argument, right? That you're pursuing. All right, we have hate crime laws that, in effect, if you're engaged in criminal conduct, but you say things that would otherwise be constitutionally protected under the First Amendment, you can be penalized more seriously. And we don't have a problem with those laws generally. How is that any different from a situation where you're violating the law through the possession of controlled substances, and then you also have a firearm, so you're penalized more heavily? How is that? How are the two different?
In the context of hate crimes, there's a nexus between the constitutionally protected activity, in this case speech, and the criminal activity, which is typically violence, destruction of property, threatening behavior, conduct that is not constitutionally protected. It's not just that someone says something horribly racist, it's that they say something horribly racist while they're menacing the target of their racism. And so the nexus really controls the constitutional argument in those cases. We also have, under the First Amendment, exemptions for certain kinds of speech that, such as true threats, that are not subject to strict scrutiny analysis. So that's very different. The nexus is missing in Iowa Code 724.8b. In this case, this court has previously recognized that the federal cases applying Bruin v. Rahimi are persuasive authority, even though they're doing a different test in those cases. And in 2 recent federal cases, which I included in my most recent supplemental authority notice, the 8th Circuit is recognizing that it's not just enough that someone is under the influence of marijuana and possessing a handgun under the federal statute that's comparable to Iowa Code 724.8b. That's 18 U.S.C. 922 G3. There's not the connection between using marijuana and possessing a handgun is not consistent with this nation's history and tradition of regulating firearm use, because not every marijuana user is dangerous. The use of marijuana and the use of a firearm together, or the possession of a firearm, is not inherently a dangerous activity. The Eighth Circuit in Cooper and Baxter compares and contrasts how some drugs, such as PCP or alcohol, do tend to make people very violent, and having those people be armed does present an inherent danger. But the marijuana user could be a grandma with a medical marijuana license. It could be someone who's using legal low-dose consumables under the Farm Act. There's not an automatic, or there's no data to support that someone who uses marijuana and possesses a firearm at the same time is automatically more likely to go home and shoot their wife in a domestic violence incident.
Just a quick clarification. You keep saying using or possessing a firearm. 724-8B references carrying. Is that a difference between 922G3 that's relevant?
The way that possession is defined under the case law. The jury instructions for possession require it to be within a person's actual physical possession or constructively possessed. So possession means more than simply owning a firearm. If I leave...
He says carrying. It doesn't say possession. The Iowa statute.
You're right, Your Honor. However, the possessing means that it's actually physically possessed, or the person constructively possess it, which means that they know where it is and have the intent to possess it.
The same as carrying. Yes.
Your last argument, you were saying that if this wasn't marijuana, but instead maybe was methamphetamine or something more associated with violence, the statute might survive?
Closeness of fit for this statute. Strict scrutiny requires it to be narrowly tailored to serve that government interest. This statute includes a lot of behavior where a firearm does not make the commission of a crime inherently more dangerous, and it also excludes some behavior where the commission of a crime is, along with a firearm, is inherently more dangerous. 724.8B applies to indictable offenses. Public intoxication is a simple misdemeanor, not an indictable offense. It's not covered by this statute.
Let me ask you about go back to the user quantity question. Let's say that instead of a small quantity, as you suggest, because I note that your client also had a scale, right? And let's say they had a scale and then they had 200 pounds of marijuana. We wouldn't have a problem here today.
100 pounds of marijuana likely would have been led to him being charged with possession with intent to distribute, which is a very different crime. Distribution of marijuana carries different risks than merely possessing marijuana. It seems, as a criminal defense attorney, that most of our murders here in town lately are drug deals gone wrong. They're drug robberies. And in those cases, there's a different gun offense that fits. It's using a firearm in furtherance of that drug trafficking. So we have more than just the temporal connection between the two separate acts. We have
the fact that there's a potential for firearm violence in any drug transaction just make it inherently dangerous. Whether or not the transaction's occurring, having a gun while you're purchasing drugs or selling drugs creates a risk of escalated violence.
Is that Iowa Code 724.8B does not require any proof that Mr. Woods was selling or purchasing these drugs in an unlawful manner.
For the marijuana, it talks about controlled substance. Aren't you asking us, in a sense, to kind of tear apart the definition of controlled substance?
The statute covers all substances that are controlled in Iowa. So if I'm carrying my hypothetical teenagers Adderall or Ritalin for them and possess...
I assume you would have a prescription for your child.
Yes. There's, yes, maybe my child was a bad example. Maybe I'm carrying my husband's Ritalin. And he's nowhere around and I don't have the prescription handy. I'm technically violating the Iowa Controlled Substance Act.
Charges like that, and then evidence is presented to show that she was simply carrying it. But my point is, aren't you kind of asking us to look at controlled substance from a different angle, depending on what it is?
Exactly what the Eighth Circuit's doing in Cooper and Baxter. It is a difficult test to apply, but when we're adapting Iowa Constitutional Amendment 1A and putting it at the top of Article 1 and emphasizing how important it is, the importance of gun rights demands that we undertake this difficult analysis.
Perhaps maybe the job of the legislature to decide whether or not we should tweak the controlled substance to line up more with what they intended by 1A?
We've got to give them some guidance on how to do that. The plain language of Iowa Constitutional Amendment 1A says apply strict scrutiny to protect this fundamental right.
Discussion about how this would play out differently with different quantities or different substances. It seems like an as-applied challenge is the best you're going to be able to sustain.
I think that's fair, Your Honor. I think there are applications of the statute which would pass strict scrutiny. Before the district court, the focus was on the specific fact of Mr. Wood's offenses, and we're making the same arguments here that we made before the district court.
Under the influence here, as I read the police report, it describes him as sober.
Correct, Your Honor. He was not under the influence. He was not charged with OWI. There's no evidence to suggest that there was any level of intoxication, let alone a level of intoxication that would make him dangerous.
That the federal statute, G1, deals with a user, so somebody who may not actually be in possession of a substance at the time they're carrying the gun, versus our statute, which requires a nexus between having the gun while you're committing a criminal offense.
Absolutely, it matters. One of the interesting things about 922 is that the government has to prove a consistent level of intoxication or use contemporaneous with the firearm possession that would make the person dangerous, consistent with the historical tradition of disarming the people who are mentally insane or intoxicated. From a purely metaphysical standpoint, someone who has used drugs has been in possession of drugs. The federal government's, in analyzing this issue under Rahimi, is looking at dangerousness. So there's, the Iowa statute is even further removed from that dangerousness analysis that's required.
Right, I mean, you're not denying carrying the marijuana was a crime.
So is using marijuana, because you have to possess it to use it.
It doesn't rely on the actual possession, it's just the use. I mean, I've never seen a case in Iowa, maybe you've seen one, where somebody was charged with possession because they were found high, 10 hours later after they were using it. Are you aware of such a case?
Your Honor, but I think the distinction is that the intoxication is important because it's tied to dangerousness and it's tied to the compelling state interest of Iowa Code 724.8b, which is to prevent dangerous behavior. But possessing marijuana, a user quantity of marijuana, which was legally purchased outside of the state and for which there is no intent to distribute, is not made inherently more dangerous because there's a firearm there. But intoxication and marijuana...
Officer interacting with a citizen who's committing a crime and carrying a handgun at the same time. I think we could all agree that just as a matter of fact, having a handgun in the car accessible to the defendant is more dangerous than not having a handgun from the officer's perspective, right?
But that's a policy argument. Well...
Gun just isn't inherently more dangerous than not having a handgun?
Person who's determined to do harm to a police officer and who has a handgun is going to do more harm to a police officer than one who does not have a firearm. That's absolutely true, but that's a policy argument about whether or not Constitutional Amendment 1A is a...
Job of the legislature?
About whether Constitutional Amendment 1A is a good idea or not, or whether the Second Amendment is a good idea or not. The legislature's already told us it's a good idea. They worked very hard to pass this constitutional amendment and to put it at the top of Article 1 and emphasize its importance over other constitutional rights.
Have a choice to decide this under the Second Amendment or the Iowa Constitution. What's your position?
I think you're probably a little safer under the Iowa Constitution. This is a rapidly developing area in the federal courts, and it's not fully settled. The fact that I filed 2 supplemental authority notices probably gives you some clues there. But I do think that the argument under both constitutions is clear. I think Mr. Woods rights were violated under both constitutions, and the court is free to reach both.
The Iowa Constitution, you just mentioned that the legislature tried really hard to get 1A passed. What does that say about the statutes that were on the books at the time 1A was passed?
My time has expired, if I may briefly answer. The Constitution trumps the statutes. The statutes have to be interpreted through the lens of the Constitution itself. There's certainly some statutes on the books that might be inconsistent with the constitutional amendment. It could be that our legislature was doing some of these things at the same time. Whether that was wise or the most efficient action or thoroughly thought out by the legislature, this court has the responsibility to uphold the Iowa Constitution. So the constitutional amendment trumps. Thank you.
With something that we never talked about with her, but it's kind of the doorway into this case, is the conditional guilty plea.
May it please the court. Opposing counsel. Beginning with the conditional guilty plea, we have a rule of 814.6. And ordinarily, when a defendant pleads guilty, it's their burden to show under a good cause, for example, is one way to do it, that there is good cause for this court to hear their guilty plea. Under a lower, I think it's subsection 3 of 814.6, there's various requirements that a defendant must meet before this court has jurisdiction. So of course we have the rule 2.8 below, which, agreement of the parties in writing with the court on a pretrial motion with the errors been preserved. Then additionally, for jurisdiction under 814, we have similar rules, but then we have additional language of in the interests of justice. And the interest of justice here is something that hasn't been defined by this court. I am aware of the 2 Court of Appeals cases that have discussed it, but the mention of the jurisdiction here is just to point out that simply saying it's in the interest of justice doesn't necessarily mean that something is. And for example, I think something that wouldn't pass the 814 conditional guilty plea is an issue that's not preserved. And so even though the parties agreed, and even though this was raised in a pretrial motion, if, for example, here, and I think this is a good example, where we have the First Amendment and we also have the First Amendment under Iowa Constitution, but then also the Second Amendment, but then there's also this due process issue. And if we look at the language of the guilty plea, we see Article 1, Section 1A, we see the Second Amendment, but we don't see due process.
Her preservation standards resolve this issue? Do we have to get into interest of justice?
A good way to look at this as well is that certainly interest of justice must mean something more than just error preservation. But looking at the 814 here, jurisdiction and error preservation there coincide with each other, where it wouldn't be in the interest of justice to decide something that's not preserved. So perhaps that's defining it by looking at this case, but that's exactly the point, which is that in the interest of justice hasn't been defined, and that here error preservation would prevent this court from considering the due process question.
If we have appellate jurisdiction on one issue, the other, we can decide the others that come along with it. Is that an answer to that concern?
And that thought process, but I think the problem there is that would open the door too widely to consider issues that weren't conditioned on that guilty plea.
That error was preserved on our Second Amendment and 1A challenges?
Challenge. I think that when we look at whether something's facial or as applied, we don't need magic words necessarily, and the relief is an important part of that. So when we grant relief on a facial challenge versus granting relief on an as applied challenge, that means something different.
Their error not preserved on an as applied challenge under either amendment?
The motion to dismiss, the language of that itself, combined with the language of the arguments at the transcript, we're looking at hypothetical scenarios that are unlike this defendant.
That's part of an as-applied challenge, too. You say it's unconstitutional as applied to me. I mean, we work through that. We ask hypotheticals from the bench all the time. And in evaluating whether it's constitutional as applied to this case, you think about how it would work in other cases.
And I think that
Things up.
though at the as-applied argument here, which would require specific fact findings about this individual. So under Rule 211 for the motion to dismiss in criminal.
The fact finding that they're only requiring, the only argument they're making, the only fact is this was marijuana. That's the only thing I'm hearing. It was a possession charge of marijuana. They're not extending it to other scenarios with other substances. Why can't we just deal with that as applied challenge? With that being the factual record, that being the argument they made, it's before us. Why can't we decide it?
That as this court and the United States Supreme Court has recognized is that litigants bring facial challenges at a cost because there are a high burden to meet what a facial relief would require. So yes, litigants absolutely could bring as applied challenges, but it requires them to look at the facts of their own case and decide the facts of their own case here.
Challenge, they get to pick the scope of their challenge, and their challenge is marijuana, as I understand it. They're not challenging whether the statute would be constitutional as applied to some other substance, but as to this case where this person was in the car with marijuana, it seems to me you're just trying to, kind of bob and weave and make it hard for them to challenge anything.
That's certainly not my intent, Your Honor. I do think it's important to resolve the issue at hand. So to the extent that this court and the U.S. Supreme Court agree that resolving cases as applied is the preferred method because we're only resolving the question at hand and giving the relief needed to resolve this case. To the extent this court finds that an as-applied challenge survives, the state maintains that the as-applied challenge would still fail under the Second Amendment and Article 1, Section 1A. And it's merely to point out the relief that was requested below and the scope of the relief that this court can grant. So if this court finds that an as-applied challenge was preserved, then the relief that's granted is only related to the circumstances of this defendant and applied to this defendant.
On the cases interpreting Section 922G, they seem to be saying, at least the ones that I've read, that there can be as-applied challenges where a person is simply alleged to have been an addict or prior user. Why is this case different than those cases where here the person isn't even alleged to have actually used, just simply possessing it?
So 922G3 looks at drug users, so a regular drug user, habitual drug user. And that's saying, so for example, and I think Daniels outlines the problem with this, at least in the Second Amendment context, is that you could use marijuana on Monday and still not possess a firearm on Wednesday. And so our analysis when we're looking at the 922G3 cases is that we need to look at the scope of the law and the scope of what conduct too that criminal law is prohibiting. And also look at what is the aim of that law too. The aim of that law is preventing someone who is a known drug user from possessing firearms. And I think it's really important here to look at what the actual language of 724(8)B says. And it's that when you are currently possessing a controlled substance, you can't also carry a firearm. I think the narrowness of Iowa's law as opposed to the 922G3 gets us into an entirely different historical analysis.
The historical analog to simple possession, because they had drugs at the time of the founding, and I'm not aware of any statute that says that simply possessing drugs at that time would prohibit you from having firearms.
Certainly, and I think that some of the concurrences discuss this in Rahimi too, which is the idea of we can't expect that the laws today are fitting a mold. They're to fit a principle and not a mold. And so simply because the policy decisions of 18th century or 1791 and pre and post ratification legislatures have made the policy choice to not criminalize substance use doesn't mean that we can't then criminalize substance use here today in the 21st century.
Assume that we agree that the Second Amendment or Article 1A requires some showing of dangerousness. How would that be done procedurally? So would it be a jury instruction in a case charging this? And if that's right, could we make that finding based on the minutes of testimony here, since it was a guilty plea?
Answering it under the Second Amendment. Well, and I guess my first answer under both is that no, I don't think that there needs to be a fact finding in the jury instructions on dangerousness. Beginning with the Second Amendment, I think that Judge Colleton's Jackson opinion discusses this at length, of the idea that we can categorically ban people that are perceived as dangerous. And so the law here is independently, with or without a firearm, you cannot possess a controlled substance. And the legislature has done that because controlled substances are a Schedule I violation, or Schedule I drug. And that's something that means there's no known medical use of it, and that has a high risk of danger. And marijuana is still a Schedule I drug. So then under the Iowa Constitution, I also don't think there needs to be this separate finding in the jury instruction. And I think that the same idea is that the state can have a compelling interest in preventing firearm violence by looking categories of people, which would be those that are possessing drugs, and narrowly limit when they can carry a firearm by only saying that when you're possessing that illegal drug, that you can't also carry a firearm.
We have to look deeper than that, right? I mean, as I read the current cases on 922G, they're all talking about looking at what the actual individual was doing. Don't we have to do that here?
Yes, I agree that we have to look at what they were doing, and here it's the possession of marijuana is what separates them from the law-abiding ordinary citizen. And I think when we look at the concerns that Rahimi and that Bruin outline, yes.
Contesting whether or not a showing of dangerousness is required? Or are you conceding that point in saying that as a categorical matter, as a matter of law, possession of drugs and guns at the same time is dangerous and there's no problem?
The latter. So the finding that the decision for this individual, Mr. Woods, to not use his firearm against this officer does not undercut the state's compelling interest to preventing that situation from happening in the first place. To possess drugs, even if you're not trafficking them, it assumes that because it's necessary in the illegal possession of it, that you acquired it from an illegal means. Now, I understand that my opposing counsel, yes.
So you're basically saying that if you're violating a law and you have a gun with you, that creates a dangerous situation that the legislature should be able to prohibit. And so, for example, if you're, the treasurer at a religious organization and you're taking, $30 a week out of the till, then that would mean that you're committing a crime, and maybe you have your documents that show that with you. Who knows? And so, having a gun with you, that makes you a dangerous person. Is that true?
Back up a little bit in the hypothetical and know that there are certainly an increased risk of danger whenever a firearm is involved. But where the legislature stepped in is when that risk of dangerousness is too high to stomach. So it's indictables and it's controlled substances. So certainly,
it is an indictable to commit intellectual property counterfeiting. If I'm carrying a pirated copy of the Little Mermaid on Blu-ray and I'm going to sell it, is that dangerous? Is that something that I shouldn't be able to carry a firearm while holding that?
the state's position is yes, because of the risk that it poses to law enforcement. Because the idea that if the law enforcement came to investigate that crime, the underlying idea here is that indictables carry a maximum of 1 year in jail. The idea is that there's an indictable offense that the legislature has determined is dangerous enough that you need to be incarcerated for 1 year. And when a law enforcement gets involved in that situation, the risk of apprehension to avoid the more serious crime is what this law is seeking to prevent.
Require any kind of factual backup for your claim. And here's what I'm getting at is you say that there's a theoretical 1 year, and on the books, it's a 1 year possibility of incarceration. But let's say that in the history of Iowa, no one who, had a pirated mermaid tape had ever gotten anything except a deferred. Would that matter? I mean, and likewise, bringing it back to this situation, I mean, user quantity marijuana folks often are getting are not doing full years. So do we have to get into that granular level and say, well, you know, they probably get probation and maybe that makes them a little less dangerous, or not?
Believe that we need to get that granular with it because it's the idea that it's the legislature has determined that when you are subject to up to a year in jail, that those types of offenses, indictables, and I recognize too that possession of marijuana is 6 months, but when you get to that year is when you also possess marijuana and a firearm. So it's still consistent with this indictable. But to your point that we don't need to get that granular, and I think that that might raise a potential as applied challenge to that type of crime of theft with the DVD, and that would be potentially a different as-applied challenge. But looking here at the risk that someone that possesses marijuana and only looking at it if they're distributing it ignores the fact that you received it. And I understand.
Be submitted to a jury. I mean, if the state's conceding that dangerousness is required, why can't we just, on a case-by-case basis, just have a jury instruction that says, the possession of the handgun and the commission of this crime at the same time was dangerous. And the jury can decide that, and it kind of resolves all these as-applied challenges.
I want to make sure that I didn't misspeak before, and I see that my time is about to expire. May I finish this question? I want to make sure that I was clear in my answer too. I think that categorically, when someone possesses a controlled substance and a firearm, that sets them apart and that makes them dangerous. I don't believe that there needs to be an individualized finding that each person that possesses a controlled substance does something that makes them therefore more dangerous. So if I was unclear on that before, I wanted to clarify that. Okay.
I mean, if there are not crimes about controlled substances, the Little Mermaid video, why wouldn't we just submit to the jury, if we believe the Constitution requires some showing of dangerous before somebody can be convicted of possessing a firearm, why don't we just let a jury make that determination in every single case, rather than just making a categorical rule?
I think that this gets closer to Chief Justice Christensen's point to begin with, which is that the legislature is the one that has the power to decide which conduct is dangerous and which conduct isn't, obviously within bounds, but that having a jury determine if this is the kind of conduct that then made possessing a firearm more dangerous is better suited with the legislature for rules that lay out this specific type of conduct, like here in 724.
Guys, I was unfair to you earlier. Your argument's been very helpful to me, and this distinction between as applied and facial is not apparent. But it does seem to me that the problem with that approach is then the Article 1, Section 1A means something different from case to case, because jurors aren't going to necessarily decide the same thing in any different case. And normally, we decide what the Constitutional requires.
I understand that this is under the Second Amendment with federal case law, but again, the Jackson decision out of the Eighth Circuit discusses that we don't need to go felony by felony. A nonviolent felony is still a felony, and therefore it's dangerous and categorically able to be determined to not be able to possess a firearm. Again, this is a limited circumstance where only when you are possessing the marijuana is when that determination has already been made.
That is, when I was in practice, because Justice McDermott didn't practice very much in the era of DVDs and VHS tapes. I did get involved in some seizures, and we had federal marshals that came with us. So when we conducted those seizures, so.
If there are no further questions, the state asks that this court affirm. Yes.
Talk got me thinking. Just so I understand, part of your argument before was about that the legislature's decision in this case is based in part on the dangerousness of marijuana. Is Schedule I drug, right? That was your point. Isn't that a measure of the dangerousness of the drug to the person who uses it? In other words, isn't it sort of a protective measure towards people versus Like as you say, sometimes PCP, for example, is a classic, right? Associated with danger to others. Could you just help me with that distinction and how it matters here?
So as it stands, marijuana is a Schedule I drug under both federal and state law. When someone possesses a drug, it necessarily implies that they'll use it, and I think that gets at that point of the protecting someone from having a firearm and using a drug. But more than that, 724(8)B protects against illegal drug trafficking, because the idea of drug trafficking, when a drug is a Schedule I drug, that inherently creates a dangerous marketplace of this drug where a firearm and the possession should be separated. And I think that distinction too is laid out in the Louisiana case of Webb. And Webb at the time in 2012 did not accept marijuana from it. The Webb decision was looking at controlled substances in 2012, and controlled substances in Louisiana in 2012 did include marijuana. If there are no further questions, the state asks to affirm. Thank you.
Thank you, Your Honors. I'd like to start briefly on the idea that there's a preservation issue in this case because of as applied versus facial reasons. And I think that Judge Strass in the Eighth Circuit explained this really well in United States v. Cooper, which was in my latest supplemental authority notice. The outer bounds of the Second Amendment are always defined by historical tradition, or in Iowa under Amendment 1A, defined by strict scrutiny. The appropriate analysis, whether it's the historical analogs test from Bruin and Rahimi or the strict scrutiny test under Amendment 1A, stays the same regardless of whether it's a facial challenge or an as-applied challenge. The only thing that changes is, of course, the remedy. Is Mr. Wood's indictment or conviction vacated, indictment dismissed, or is the statute as an entirety invalidated? So this is not an error preservation issue. We're making the same arguments here that were made before the district court and ruled on by the district court. Error was preserved. This is a remedy issue. To briefly adjust whether it's in the interest of justice for this court to hear this appeal, of course it is. This is something that's incredibly important to Iowans. Our liberties we prize and our rights we will maintain, and fundamental among those rights is the right to own a firearm. This is a constitutional amendment that has to be interpreted so that Iowans know when they can exercise their rights to defend themselves. Now, the state is very concerned about illegal drug trafficking and the risk that possessing a firearm, carrying a firearm, inserts into illegal drug trafficking. But again, you have to look at the facts of this case. This was marijuana carrying commercial labels that was legally purchased. It contained the THC warning labels that are required by states that allow the legal purchase of marijuana. There was no indicia of unlawful drug dealing. We simply have unlawful drug possessing. There's nothing to suggest in this case that Mr. Woods was going to go sell that marijuana or that he purchased it from someone who could not legally sell it outside of the state.
Whether he had the firearm when he purchased it?
I know that.
How is this going to be adjudicated case by case? What is that going to look like procedurally?
The way the Eighth Circuit is handling it is that it needs to be an as-applied challenge. And the Cooper and the Baxter cases were remanded for fact-finding by the judge to determine whether those specific defendants' marijuana use made their possession of a firearm dangerous in a way that had a historical analog to laws disarming the mentally insane or the intoxicated.
It wasn't a guilty plea and it was a trial. How would that have played out at trial?
I think it's up to the judge and not the jury to determine whether or not conduct is constitutional. So I believe the way that I'm reading Cooper and Baxter, it would have been a pre-answer motion to dismiss issue. Not a pre-answer, but a pre-trial motion to dismiss issue. That's what the remands were for in Cooper and Baxter.
that point, the state could put on evidence, let's say your client actually is a drug dealer, even though he had a small quantity in this case. It could put on, evidence about his prior history of violence. Is that relevant?
In Cooper and Baxter, in Baxter, part of the remand included instructions to the court to figure out what sort of evidentiary hearing it could have under the rules of criminal procedure. I think in Iowa, the rules of criminal procedure are clear that a pretrial motion to dismiss assumes the facts in the minutes of testimony is true. So I think following the rules of procedure in Iowa, we would do exactly what we did in this case, which is look at the minutes of testimony, look at Mr. Wood's specific conduct as established by the minutes, and determine whether or not there was a constitutional violation based on that nucleus of facts.
Those minutes show that upon getting pulled over, he did disclose to the officer that he had a firearm in his backpack.
Did everything that he was supposed to do, and I think it's important to note that he was driving a commercial vehicle and that this was a stop by a trooper who was working with the DOT for commercial vehicle enforcement. He wasn't speeding, he had a trailer light that wasn't working, and he was fully cooperated with the law enforcement officer at every step of the equipment test, including telling him he had a firearm and that there would be more marijuana found in his backpack, in addition to the 2 THC vape pens that the officer observed in plain view. Thank you, Your Honors. My time has expired. We ask that you reverse the district court and vacate Mr. Wood's conviction.
Woods is hereby submitted, and court will adjourn for the morning.